What time does court start then?
Court started at 8:45. I went to the wrong place. I do apologize for that. That is definitely my.
Please be on time next time.
Yes, sir.
Okay. Ma'am, you are charged with assault of a family member.
Right here, the judge is laying out the stakes. Assault of a family member in Texas is no small charge. Up to a year in jail and a $4,000 fine. Notice how quickly he pivots into the Miranda-style rights? That's because everything from this moment on could become evidence. Audience question: do you think the defendant is already digging themselves into a deeper hole with these slip-ups?
You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you. Oh my Lord, this case is 1,600 days old?
I didn't, I forgot.
Stop.
Sorry.
You're in enough as it is. Now, I am not happy with you, ma'am. Can you read to me what happened, please?
Sure. On February 1st, 2020, officers were dispatched to a disturbance at an apartment in Harris County. When they arrived on scene, they were met by the defendant, who confirmed that a disturbance had taken place. Officers asked her to stand by with other officers while they made contact with the reportee, who was identified as Mr. Ortiz. The officers observed a small amount of blood coming from the bridge of his nose and a small amount of blood on his teeth. He advised that he lived at the location with the defendant, who identified herself as his girlfriend. Ortiz advised that he came home to the apartment at approximately 3 a.m, got to his bed with the defendant, and there was no disturbance or argument when he got to the bed. He advised that his presence in bed was known, and it seemed as if his presence was comforting to Ms. Martinez. Approximately 15 minutes prior to calling the police, Ortiz was awoken by Martinez screaming at him to get out of her bed. She began to lift up his body and began to strike him in the face with her hand. Ortiz described these strikes as punches and advised he did feel pain after getting out of the bed. And then the two of them got into a verbal altercation, which resulted in Ms. Martinez throwing water on Mr. Ortiz. He stated that he believed this to be an attempt to wash the blood off of his face. Due to the incident, he contacted 911. Defendant stated that she pushed Mr. Ortiz in an attempt to get him out of her bed, and that she might have slapped him.
And I'm going to find that there's probable cause to go forward with the case.
This is courtroom drama at its finest. The judge is basically saying, you disappear again, and I'll make your bond skyrocket. A GPS monitor is no joke. It means the court literally doesn't trust you to stay put. Think about it. Would you risk losing thousands just to dodge a hearing?
Ordered you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. It would behoove you to get a lawyer as soon as possible. I will, at the next setting, set your case for trial. I'm now also ordering you today, you will get a GPS monitor that you will be required to pay for, ma'am. If you ever take off on me again, I will quintuple the bond on you. Your case is 1,600 days old, and you have taken off, as far as I can see, 1, 2, 3, 4, 5. The only reason you're not going into custody now is because you paid a surety bond. But I'm going to tell you now, next time you take off, 5 times goes the bond. Well, actually, perhaps 6 times for as many times as you've missed. So she gets a GPS monitor today. And well, hold on a second. I still have to enter in the MOA. I'm entering what's called a magistrate's order for emergency protection. That is a court order that identifies Chase and Ortiz as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. No one can authorize you to violate this. And I'm telling you now, you pick up a new case or you don't come to court when you're supposed to next time. Do you understand me? I mean, I'm so upset that I can't even see straight. I'm going to have you come up here, sign the MOA. I will get you to Victoria. The next setting is player trial. Okay. So 3 weeks. And then you will get to Tracy, where you get your bond conditions, man. Okay.
Logan, can you refile them all? It's just one page. It doesn't have an order.
For which, Martinez?
Please.
Please, with Victoria.
Judge, is that CHA?
Yes. So you're charged with 2 counts of assault with bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews of the state of Texas. If you cannot afford a lawyer will be appointed to represent you. Sir.
On June 7th, 2024, officers were dispatched to an assault in progress call at a gas station in Harris County, Texas. Officers spoke with 2 complainants who stated they were assaulted by the defendant. 2 complainants are sisters. 2 complainants are sisters, and the defendant is their friend. Complaining witness Richardson said that she and her sister and the defendant were having an argument at a bar, and they all got into a vehicle to leave the bar. Defendant was sitting in the second row of the vehicle. Complaining witness Lassiter was driving, and complaining witness Richardson was in the passenger seat. At some point, the defendant kicked complaining witness Richardson in the face 4 times. Complaining witness Lassiter stopped to check on what happened, and she felt pain in her lip. She believes the defendant used a closed fist to assault her. Defendant stated that he was drunk and wanted to go by himself, but the complaining witness refused to let him leave. One complaining witness grabbed both his arms and he spat on them, and they started.
So on the first young lady, she gets kicked in the mouth, you said?
They observed a red mark like a shoe sole on her forehead, Your Honor.
Okay. What else?
And then we had reached the end of it. It just says that complaining witness Lassiter had a small laceration on her lip. And then we have a 2020 ABI adjudicated by the U.S. Army and a 2024 DWI out of North Carolina.
Mr. Mitchell, I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or dope, I will revoke your bond. I will put you in jail. I don't care where you are in this life. I don't care where you are, what state you're in. Do you understand?
Yes,
If
sir.
I find that you're consuming alcohol, I will put you in jail. Likewise, I'm ordering you not to have any contact with the complaining witness in either of these cases and not to be in possession of any weapons. If you violate these conditions, likewise, your bond will be revoked. You will go to jail.
When he does his randoms and check-in and they say his number is up, can he do that in North Carolina?
Yeah, he will have to go to a Quest Diagnostics.
Okay, perfect.
It is up to you to go to a Quest Diagnostic, get the result to your lawyer, and she will get it to the appropriate people here, pretrial services. If you don't do the drug test when you're required to, you already know what's going to happen.
Yes, sir.
For now, I'm going to have you go to Victoria. We're going to have you sign a reset. After that, you'll get with Tracy for your bond conditions. No alcohol, no dope, no weapons, and no contact with either of these complaining witnesses. Do you understand?
Yes, sir.
Okay.
Thank you, Judge.
Sir, you're charged with assault and bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The 23rd of January, 2024, officers were dispatched to a Code 2 priority assault in progress on Ralston Street in Harris County, Texas. Complainant stated that tonight he walked out and noticed an extension cord plugged into his exterior outlet outside his front door. Complainant stated he knocked on the defendant's door and he told them their power was out and he needed to borrow some power from the complainant. Complainant told him to unplug it as he could not afford to power 2 homes. Complainant stated the defendant got mad and punched him in the bottom lip a couple times with a closed fist, causing pain. And let me see, I see a felon in possession of a weapon. Let me run.
He's currently on deferred now. You're on deferred for a very serious offense. You've now picked up a new case. That's not a good thing, sir. I'm telling you, it's a matter of time before they issue a felony warrant on you. And then we're going to try to revoke your probation, and you're looking at 2 to 10 in the penitentiary at a minimum. So be on the lookout, sir. What do you do for a living? Sorry? Okay. How much money do you make a month, sir? Okay. We're going to reset your case to give you time to hire a lawyer. I would get on it quick because I'm telling you, a felony warrant will issue any minute. I am ordering you now as a condition of your bond not to have any contact with the complaining witness in this case and not to go within 200 feet of where he lives or where he works. Do you understand? I'm also ordering you not to be in possession of any weapons. On that case, would you mind filing no contact and no weapons, please?
Yes, Your Honor.
I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in your jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. Get on it quick. All right.
All right, Judge, page 12 and 13, 4, come on up.
Ma'am, you were charged with terroristic threat of a family or a household member. That allegation.
Whoa, hammer in hand, threats being shouted, a 14-year-old witness in the mix. This just escalated from a family argument to a serious terroristic threat case. And here's the kicker, prior convictions from multiple states are now in play. That history can seriously sway a judge's patience or lack thereof. What do you think? Should prior offenses weigh this heavily in bond decisions?
Kicks up to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford one, one will be appointed to you. Okay.
On the 11th of June, 2024, officers were dispatched to a disturbance with weapon call. Officer heard defendant scream from within the house. Someone advised the officer that he would need to go around back because the door was broken. Officers observed complaining witness exit the back of the residence and defendant exit holding a hammer, screaming, acting belligerent. Officer told her to drop the hammer and she did not. Officer grabbed the hammer and flung it across the yard. Complaining witness advised that she is his ex and she threatened him with a hammer. I'm going to say defendant advised that she is complaining witness's ex and she threatened him with the hammer. When he attempted to kick her out of the residence, she threatened to kill him. 14-year-old witness corroborated the story. Defendant says, complaining witness says he pulled a gun on her. Officers searched the house for a gun, but none was found. So we have a 2010 ag battery out of Indiana, 2013 invasion of privacy from Indiana, 2013 forgery attempted theft, 2016 DWI, 2020 DWI.
What was the threat again?
Let me check the DIMS, Your Honor.
Did I not?
It said briefly that I'm going to kill you, but I'm just trying to see if the officers took down the exact words. Complainant stated the defendant told her that she was going to kill him. And the complainant stated the defendant at one point threatened to kill him. That's the threat.
Ms. Jones, I'm going to find that there's probable cause to go forward with your case. There's a protective order that's been issued. Please get to know it. If you do something to violate, I know that you want to say something, but I want you to listen. I will give you a second to talk, but just hear me out for 1 second. There's a protective order in place. Get to know it. If you do something to violate that protective order, the state will file a violation of protective order against you. The only thing I'm asking you at this point is do not have any contact with this person. Do not have any weapons. Do you have a question? I don't want to talk about the case, though. I have a bunch of DAs here. Anything you say, they're going to use it against you. He's going to sit there. He's going to type up everything you say. Just don't. What do you do for a living, man?
I do home health aid work. I do home health aid.
What kind of income do you have?
Right now, I don't have any whatsoever.
I will appoint your lawyer today. You can tell your side to the lawyer, and the lawyers can speak to the DAs on your behalf, but just don't say anything now because it won't go well.
I have a new number because he broke my phone.
Say that again.
How to say that?
Just hang tight. What I'll do, let me give you a lawyer. You can explain everything to the lawyer. If it's something that needs my attention, they can tell me. Okay, as it stands now, no contact, no weapons, no going back to this house. Well, you ask the lawyer and the lawyer can advise you on that. So for now, I'm going to have you go to Victoria Center Reset. I will have you take your seat in the jury box. I'm going to get these bond conditions. Do not leave until you sign these bond conditions. Otherwise, I will issue a warrant. Okay, please come up here, pants almost down to your knees, swagger. You know what creates swagger? This. Knowledge. That's what gives swagger, not the way you're handling things now. That's not swagger, dude. Money, knowledge, power. That's swagger. And I'm going to tell you, you get a conviction, it's going to hose you for the rest of your life. You will never attain any kind of swagger with that kind of misdemeanor on your record. You have until Monday. If you do not have everything done by Monday, then I will set your case for trial and it's all over. I will not accept anything else from you. Do you understand, sir? If you have the heart in life, you can achieve anything. Because that's all it takes is heart. You have until Monday.
So have it done now.
Counsel.
Thank you.
I remember you, and I'm going to tell you
Te
now
voy a decir ahora,
that not only
no solo
do you have one case,
hice un caso,
but while you were on bond for your first case,
cancha por el primer
you picked
caso,
up a second case, and you have repeatedly failed to appear for court.
dado de comparecer a tribunales.
We have given you multiple PR bonds.
eh,
That ends today.
Personales. Eso termina el día de hoy.
On his new theft,
En su nuevo
probable
caso,
cause was found, right?
causa razonable se falló.
I can't see on my end, Your Honor.
Yo no puedo ver de mi.
I guess let's do this. If I remember correctly, this is the gentleman that went to the Galleria, stole sunglasses on the first theft, right?
Galería y se robó unos
Right? So then, if I remember also correctly, he gets out of here and a week later, he picks up another theft.
Otro
Well,
caso
so
de
the
hurto,
first one, Your
robo.
Honor, was at
Primero,
Dick's Sporting
fue en
Goods,
Dick's
and while he
Sporting
was on
Goods, mientras
bond
estaba
for Dick's
libre
Sporting
por
Goods
por lo de
then
Dick's
he goes to the
Dick's
Galleria.
Sporting Goods, se va a Galería a robar de nuevo.
Mr. Boza
Señor
Rosales,
Boza Rosales,
as a first thing,
como la
ordering you
le voy a ordenar a
to
usted
go back to
primero
the Houston
que no
Galleria.
regrese a Houston Galleria.
I am also ordering you now as a condition of your bond not to go to Dick's Sporting Goods. Number 3, you have been given multiple opportunities. You completely failed to appear time after time. You pick up another case while you're on bond. It goes with you.
Tiene otro caso.
I will appoint your lawyer today. It goes with you though.